This short video will provide you with some key points to assist you in preparing for your deposition. If you've never been through a deposition before, this material will help you. I'm Brett Godfrey, a trial lawyer with more than 30 years of experience and more than 100 jury trials. I'm also the founder of Godfrey Johnson PC, a Denver-based law firm with a national practice that involves high-stakes, complex litigation throughout the United States. Our web address is gojolaw.com, and our phone number is 303-228-0700. The material that follows should not be considered as legal advice unless it is supplied by us to someone we actually represent. If you are a client of the firm, you will likely be provided with this information in the form of a live presentation that is modified to suit your specific needs and the details of your legal matter. We make this information available online as a preview of how we may actually advise you if you are a client at that time. A deposition is a formal legal proceeding, but it usually takes place in an office rather than a courtroom. Your testimony will be given by you, under oath, in a room full of lawyers, while a court reporter takes down all that is said. The process typically lasts a few hours, but rarely more than one day. Some depositions last only a few minutes. Experience has taught us that the single most important problem faced by a witness giving a deposition is related to that person's thoughts and feelings about the process. So we'll take a moment to discuss those issues. The first psychological issue that can get in a person's way when they are preparing for a deposition is that of confusion. We don't want you suffering from these feelings and sensations, so we'll help you get rid of them during this presentation. The key to preparing for a deposition is to prepare, which means to know what to expect and how to handle questions. This old saying is still valuable. Remember the 5 Ps. Prior preparation prevents poor performance. Of course, you may have heard a different version of this with 6 Ps, but we like the shorter version because we don't swear in our training videos. The second most troublesome source of difficulty for some witnesses is that they are apprehensive or anxious about testifying. Like confusion, fear is merely the product of how you look at the process and your lack of knowledge about what to expect. Fear causes a person's ability to think clearly to be reduced and can lead to poor testimony. Fortunately, it's easy to deal with. One cause of fear is the belief that the lawyer taking the deposition, who's asking the questions, is a powerful, scary creature, someone to be feared. But that isn't the case. The person with all the power in a deposition is the witness, because only the witness has the ability to actually control the content of the testimony. Lawyers don't bite. It's against the rules. They may try to seem intimidating, but they have no power to hurt you if you testify truthfully. They're not even allowed to be mean to you. Knowing what to expect and how to respond to questions makes you even more powerful than that lawyer is. Thus, this process of preparation with our assistance will give you the knowledge to make you that much more powerful. Now, we have learned over time that witnesses typically have certain questions in their mind before they start preparation. The first of those is, what do I need to do to prepare? The answer to that question is, to begin with, watch this video. Come to our office. Sit down with us and we'll talk to you. The next question is, what will the deposition be like? Well, if you're prepared and you follow the advice we're giving you, it will be painless. How long will the deposition take? Well, that varies greatly. As I said, some depositions last minutes and some last hours. But most depositions last about a half a day. Who's going to be in your deposition? Well, you'll be there. We'll be there. Opposing counsel will be there, a court reporter will be there, and there may be others in attendance who simply observe the deposition. What will I be asked? Well, we're going to give you some highlights of what to expect on that subject in the images to follow. Another question that comes up is, what if there's an argument between the attorneys or A lawyer objects. We'll cover that later. Can I get in trouble? Witnesses often ask. Well, the answer is not if you testify truthfully. I've actually had some clients ask, can I be eaten alive by the opposing attorney? Answer is not if you follow these guidelines and this advice. So we're going to take it one thing at a time. We'll review topics about which you may be asked one at a time. You can take notes, but your notes may be discoverable, meaning the other side may have a right to see them, particularly if you look at them during the deposition. We'll cover more about that later. You do not have to bring documents to your deposition if you're a party. There are other channels by which information is supplied in litigation. If you're not a party to the case, and if you've received what's called a subpoena ducis tecum, it may be necessary for you to produce documents at your deposition. So, what we will cover here are deposition requirements, rules, and procedures, deposition strategy and techniques during testimony, common mistakes and challenges, legal issues and our trial plan, and our contentions in the case. We'll discuss how to handle key documents and how to further prepare after today. Being a witness during a deposition is like being on the defensive side of a football team. You can't gain ground during the deposition. You can only lose ground. Only the things you say that help the other side will be used from your deposition. So don't try to win the case in your deposition, just try to get through it without damaging yourself. We'll show you how to do that. Now, before we go further, let me point out, some depositions are videotaped. Most are not, but yours might be. We may be able to tell you in advance whether it will be that way, but if we don't know, assume that your testimony will be videotaped. The reasons for videotaping depositions will be these. First, the opponent may want this video to show to his or her client so they can get a feel for what kind of witness you are. Or to make impeachment at trial more effective. By impeachment, we mean the ability of an attorney to point it out to a jury when a witness's trial testimony varies from what he or she said in deposition before trial. Lastly, sometimes depositions are videotaped so that they can be used in mock jury trials, which are simulated trials done in private to allow law firms to understand better how to try a case and how a jury will react to witnesses. If a witness dresses badly for a deposition that is videotaped, the opposing party may play a section of the video just to show the jury what the witness looked like that day. The witness above was a defendant in a civil suit in which he was being accused of sexual assault on a child. For this witness in this case, this was a poor choice of clothing. A white shirt would have made a big difference. Some witnesses find it distracting or intimidating to be on camera. The key is to ignore the camera. Forget about it. You want your mind on your answers, your testimony, rather than on the camera. So put it out of your mind. Don't swear, don't get mad, and don't have any outbursts. If you follow this advice, the camera can't hurt you. The camera is just a recording instrument. It doesn't have any lasers or guided missiles to shoot at you. In fact, most deposition videos don't end up being used for anything. So how do depositions get used? Well, most of what's said is used from a deposition transcript in short segments of testimony. We call those sound bites. Specifically, when a witness makes an admission of a key fact that the other side wants to hang their hat on. An example would be, I never really even saw the accident, or the light was red when that car entered the intersection, or I knew before they hired me that I was a temporary employee. Things like that are hard points of fact that lawyers like to hold witnesses to, and that's why those sound bites are used. Sometimes sections of a deposition are used to support a written motion to the court of one kind or another, which is what we file when we want the judge to decide a legal issue based on the testimony itself, or the other side does the same thing. Before we dive any deeper into this discussion, here are a dozen very simple pointers to help you understand what to do. Simply knowing these things, which may seem like nothing more than simple common sense, is an important part of your preparation. So here are the 12 concepts. 1. Dress neatly. The best outfit is a comfortable business attire with nothing flashy, nothing offbeat, nothing dirty, nothing sloppy. Remember, the other attorneys are evaluating you as a witness. If you will be making a good impression on the jury at trial, they want to know that. If you make a good impression at trial, your testimony is more valuable. Next, always be polite. Your conduct and demeanor may be more important than the actual answers you give. Try to make a good impression. To relax and remain calm, trying not to show that you are nervous. It's okay to be nervous, but try not to show that if you can avoid doing so. Next, your testimony must be truthful. This is probably the single most important thing you'll hear in this presentation. Tell the truth, the whole truth, and nothing but the truth, but only in response to questions and with short answers. If you do not tell the truth, you could be subject to criminal prosecution for perjury. But remember, witnesses make mistakes. Witnesses have imperfect memories. Little things like that never lead to claims of perjury. But if you're caught deliberately misleading the court or a jury, not only could your credibility be hurt, but if it's deemed to be deliberate, you could theoretically be prosecuted for perjury. That's very rare, but it can happen, and we would be negligent if we didn't stop to tell you that right now. You must answer every question truthfully. Next, answer only from your own personal knowledge. Never volunteer an opinion unless specifically asked to do so. Never guess or speculate. Guessing or speculating is not truthful. Just don't do it. Don't let the opposing attorney fool you into making statements outside of your personal knowledge or about something you don't remember. Next, testify in your own words. Don't let opposing counsel put words in your mouth. Stay with your version of the facts as you know them. One tactic some attorneys use is to say, well, is it fair to say that? And then they go on to summarize your testimony in words they prefer. If the attorney uses a tactic like this and attempts to summarize parts of your testimony, listen very carefully to that summary and don't agree to it unless it is exactly true in all respects. If not, state that you do not agree with his or her summary. Next, remain polite and courteous at all times. Keep your guard up and don't let the opposing attorney talk you into hurting your case. Never let yourself be provoked into anger, arguing, or being upset. Also, remember, nothing is off the record. The court reporter is taking down every word. An attorney may ask you for an answer off the record, but do not fall for that. The only thing off the record will be discussions among attorneys when the reporter has been instructed to stop recording. If you make statements during a phase when the reporter has stopped recording, then that remark or statement may be brought back up when the recording is resumed. Another point is this: do not agree to provide more documents or information. There may be exceptions to that, and we'll discuss those as we move forward. During the deposition, you and your attorney might agree to produce something to the other side. If so, locate it immediately after the deposition and deliver it to your attorney as soon as possible. The next point is don't give an opinion unless asked, and even if asked, you may not have an opinion that is worth expressing under oath on the record. If it's not something you have thought about carefully, you may just decline and say, I don't have an opinion on the subject. I only know what I saw, I only know what I heard. The next point is finish your answers. If you do have a long answer to a question and the other attorney interrupts you when you're giving that answer, you should politely insist on finishing your entire answer. Just say that you were not through with your answer and insist on being allowed to finish. The next point is use care with documents. If you're asked about a certain document, you should ask to see the document before answering. And in fact, you may want to read the whole thing very carefully before answering. But never refer to a document to refresh your memory without first discussing it with your attorney. So, for example, if you brought a record with you that you might need to check before answering a question and it wasn't given to you by opposing counsel, you may have just introduced new evidence in the case, and your attorney will want to know about that before you do so. In some states, if a deponent is asked a question and stops to look at something they brought with them to refresh their memory, that document has to be disclosed, even if it was originally a privileged document. Now, when we talk about privilege, we'll get into that later to give you more information on how to understand what is privilege and what to do with that. Last, always keep your guard up. Everyone's nervous about giving a deposition. It's only natural. But sometimes as the day goes on and the original rush of adrenaline starts to subside, an opponent will lower their guard. They'll begin to relax, and they may even begin to enjoy being the center of attention. Avoid this feeling. It's dangerous and leads to your forgetting the rules given here. We'll cover this more as we move on. A common question witnesses ask is, how many questions will they ask me? And of course, we all know that that's impossible to predict, but we can give you a great answer. The exact answer is 1. There is only one question that matters, and that's the one you are answering at the time. So if you start to think in advance about a deposition is really just one question, it's the one I'm answering. You find this very helpful. There's no past, there's no future, there's only right now, the single question before you. When you're testifying, don't be thinking about deposition testimony you've already given or try to guess what the questioning lawyer will do later in the day. Just limit your thinking to correctly and carefully answering the one question that you are answering. Then wait for the next question. Listen, think, and answer that one with care. Just one question at a time. That's all that matters at any given moment. Anything else is a distraction. Deal with your deposition in this fashion, and the day will sail by, and you'll do great. We all watch TV shows and movies about lawyers and courtroom dramas. The concept of legal battle is naturally interesting. For this reason, some witnesses think it's their right or duty to do battle with the attorney on the other side, to spar with or outdo the questioning lawyer. This always makes a witness look bad. Some lawyers are good at getting witnesses to back down or to change their testimony. Those lawyers take great pride in having that skill. But if you are telling the truth and you let a lawyer push you into changing your testimony or agreeing with something that is wrong, justice will not be served and you will not be testifying truthfully. Abe Lincoln said, "Be sure to put your feet in the right place, then stand firm." Thomas Jefferson said, "In matters of style, swim with the current. In matters of principle, stand like a rock." Now, how do you do that? We like to use the acronym LUCK. That doesn't mean you rely on being lucky, but you use this acronym. Listen to the question very carefully. Make sure you fully understand the question or don't try to answer it. Consider the answer before you give it. That means stop and think before speaking. And then lastly, keep your answer short. Only answer the question and don't go beyond it. When asked about opinions, keep in mind, you are not an expert witness. You may think that you're an expert on certain things, but an expert witness is a very specific type of witness in a court of law, and whether or not a witness is an expert is controlled by the court. So don't try to be an expert in your deposition. If you were going to be called as an expert at trial, we would be providing you with an entirely different presentation. Stick with the facts about which you know and avoid offering opinions, as I mentioned earlier. Here are a few more suggestions. 1, if you don't understand a question, ask the lawyer to clarify it. Some questions could be answered truthfully in more than one way. We call those ambiguous questions. Some questions are so unclear, you might think you're answering one thing when you're really being asked another. So if you have any doubt in your mind, ask the lawyer to break down what he's asking you. Ask him to clarify his question or ask him perhaps to state it in a different way so you understand it better. Secondly, if you're a party, you can refer to the documents we've already produced in the case in general and just say, well, we've given you all of that as far as I know. or along those lines, we've made those claims clear in our court filing. We'll talk later about what to do when you're asked about your legal theories. Next, take breaks as often as needed. Witnesses should take breaks in depositions at least once every hour, sometimes more. History has taught us that witnesses who try to plow through all day without a break tend to do a poor job because their blood sugar drops, their attention fades, and they get tired. If you're asked a loaded question, you have to unload it. What we call a pregnant question or a loaded question would be something like this. Have you stopped beating your wife yet? Well, it's a loaded question because it carries with it an assumption that may not be true. In a situation like that, you would say, how can I stop beating my wife if I never have done it in the first place? We call that deconstructing the question or unloading a loaded question. If the question carries with it an assumption, and the assumption is even slightly untrue, break it down and say, that question assumes that this or that is in fact true when it's not. Tell the truth at all times. I'll repeat that over and over. And lastly, remember this last thing. Do your best. No one can ask for more. No one expects you to be perfect. No one expects you to be the perfect witness. Just do your best, and you'll do just fine. The typical subjects that are part of a deposition can be easy to predict most of the time, especially if we know how your testimony will fit into our trial presentation. But here are a few of the most common subjects about which witnesses are questioned in their depositions. You'll be asked questions about liability, which means why someone did something that is legally incorrect and leads to an obligation to pay a judgment, what the damages in the case are, and whether the damages are connected to the liability event. We call that causation. Questions about what happened before the event, during the event, and after the event are everyday fare in a deposition. You won't be just asked what you saw in the termination hearing or whatever. You'll be asked about everything that led up to it and everything that happened after it, as well as everything that happened during the event. You'll be asked about your own personal background, your training, education, and experience, your past and present employment, your medical status, and things like that. Those types of questions tend to come at the beginning of a deposition. You'll be asked about our factual claims or our factual contentions, and you'll be asked about our legal contentions. You need to understand those things to some degree before you give a deposition. But basically, the facts that you know are fair game. You're not going to be a lawyer in your deposition and asked to give legal theories. We'll cover that more later. You may be asked about discovery responses and documents that we've supplied, or questions may be directed to the names of witnesses that we have supplied to opposing counsel, or names that are found in other documents that have been supplied in the case by any party. They may ask you the identity of witnesses that they don't know about and that have not been listed in documents. Who else do you know of who saw this accident? Who else do you know of who has knowledge on this or that subject? Those are common questions. Now, sometimes lawyers get into dogfights in depositions. A lawyer might object, or lawyers might start to argue. When that happens, don't let it affect you. Remain calm. Listen and let it blow over. Don't react emotionally. This kind of dialogue between lawyers is sometimes the manifestation of the fact that one or both of the lawyers are acting out of fear. If we take someone out to the parking lot, please remain in your seat. Actually, that last point is just a joke. We almost never actually take anyone out to the parking lot, at least in the last few years. If you are a party to a case in which your deposition is being taken, you may be asked about your legal contentions. We touched on this earlier, but remember this. It is generally a bad idea for you to start giving legal theories if you're not a trained lawyer. Generally better to defer to your lawyers about questions like that. You might want to say something like, I'm here to give you facts, not legal theories. We have a lawyer for that. Now, when we use this slideshow for in-office preparation of a witness, we sometimes list at this point in the slideshow what we know specifically about the details of what the opposing attorney might try to accomplish during your deposition in light of the particular details of a case or a witness. But if you're watching this on video, it's enough for you to rely for now on the rule of simply focusing on a single question at a time. If you want to discuss this specific topic with us, please let us know. That's why we made sure to give you our phone number at the beginning of the presentation, and we'll do it again at the end. It's common for a lawyer to question witnesses during a deposition about documents or photographs. Once again, when we use this slideshow for in-office preparation, we often show the most likely exhibits to the witness during our preparation of that person for testifying. If all you have is this video, you might want to also discuss this issue with us further, or let us know if you have documents or photos that we haven't seen or discussed with you yet. One common kind of exhibit used in a deposition is email, usually sent to or received by the witness. When that happens, here is what you need to do. Read the entire email chain carefully. Don't just focus on one email if it's part of a back and forth conversation. Read the whole thing. Don't be afraid to burn time. If the questioning attorney starts to fidget or become impatient while you read the whole email, don't let that make you speed up. Ask in advance before you start to read the email what it is you're supposed to be looking for. Then read it carefully. Don't speculate beyond the face of what's on the document. You're not a mind reader, and you don't know what was in the mind of someone who wrote an email to you. You can be fairly asked to say what you thought it meant when you read it, or even what you think it might mean today, but don't speculate about what was in the mind of the person who sent you the email. You can answer questions about what was going on at that time, but don't guess about what the person meant if it isn't very clear on the face of the document. Simply say, I don't know. Defer to the author and say, ask him what he meant. Our interpretation of emails is usually to take them at face value, but if there are background facts and circumstances that make the email have different meaning than what may seem obvious, you may need to explain those circumstances when you testify about that email. Now let's talk about privilege for a minute. There are some things witnesses cannot be required to discuss in a deposition. These are topics that the law refers to as privileged information, meaning that the law protects witnesses from being questioned on those subjects. Those things include conversations between lawyers, things that you may have said to a priest or a therapist, things that we do to prepare your case for trial or that you have done to prepare for trial. And there is such a thing as a waiver to a privilege. If you volunteer something about a conversation with your lawyer, a judge may later rule that you have waived that privilege entirely, and we lose ground by the fact that you become forced to testify about private conversations the law otherwise would have protected. This is why we may object abruptly in a deposition, and we may instruct you not to answer the question. We may go beyond just objecting. We may say, do not answer that question. If you're our client, we expect you to follow that advice. It may be necessary to take a break before you answer a particular question to speak with you privately and determine whether there is, in fact, an applicable privilege. If you find yourself stumped by a question or your mind goes blank, here is how to handle that situation. First, be sure you understand the question. Sometimes people's minds go blank because the question makes no sense. I could say, for example, which is further, from here or to New York? And your brain will go blank because the question makes no sense. Deconstruct questions that have to be broken down. If a question has many parts, ask the lawyer to break it into parts and take those parts one at a time. You might ask to see a document. If you ask to see a document and it's already been discussed, you're doing the right thing. If you start to talk about a document and you haven't memorized what it says, you might be sticking your neck out and going out on a limb. Now, some kinds of materials are reference materials. Your deposition is not a memory test. If you have a document that you need to see to answer a question because you haven't memorized it, then make that clear during your deposition. If you're asked to go find a document, don't commit to the other side that you'll produce anything. That's a commitment that the attorney makes. And then finally, if you're asked a question that takes time to think through what that answer would be, or you have to analyze the question, give yourself the time to do that. Don't try to handle something that requires a math equation off the top of your head. Now, you know what to expect. and you know what to do. Armed as you now are with this information, you'll do just fine. If you would like to discuss this more, please give us a call at 303-228-0700. So let's summarize the 5 most important points we covered just now one last time. You cannot gain ground in a deposition. Only what you say to the other side that helps the other side will be used by them in the case. That's why you can't gain ground. Listen very carefully to every question. Don't let your mind wander. If you find that your mind is wandering, ask for the question to be read back or repeated, and think carefully before you answer. Answer only the question you were asked, and don't volunteer information, and ask to refer to documents if necessary. Thank you for taking the time to watch this video. You may wish to watch it again later, and we suggest that you do. For the more times you go through any given material, the better you'll remember it, and the better you'll be able to apply it. Good luck.